Good day. We hope that before you watch this, you were able to watch the first two videos because you must know the laws governing checks. We advise that you watch them first before watching this part. This would also help you in the electronic quiz that we are releasing related to Lesson 3. As promised, we will tackle the criminal and remedial law aspects of checks. Aside from these, we are including the legal ethics aspect. There is a need to include this as several cases have been decided by the Supreme Court involving lawyers issuing worthless checks and sanctioned. There are basically two criminal statutes that involve a check. First, the Batas Pambansa bilang 22 or known as the Bouncing Checks Law or more commonly known as BP 22. And second, the Revised Penal Code of the Philippines. We will be dealing with the elements, penalties, and prescription of the crimes involved. As to the first criminal law, the Bouncing Checks Law punishes a person who issues worthless check. The crime is malum prohibitum, which means that the mere commission of the act that the law prohibits and not its character or effect that determines whether or not the provision has been violated. And malice or criminal intent is completely immaterial. This is opposite to crimes which are malum in se, examples such as murder, rape, and robbery. There are two ways of violating BP 22. One, by making or drawing and issuing a check to apply on account or for value, knowing at the time of issue that the check is not sufficiently funded. And two, by having sufficient funds in or credit with the drawee bank at the time of issue but failing to do so to cover the full amount of the check when presented to the drawee bank within a period of 90 days. As to the first way, the following are the elements. A. The making, drawing, and issuance of any check to apply for account or for value. B. The knowledge of the maker, drawer, or issuer that at the time of issue he does not have sufficient funds in or credit with the drawee bank for the payment of such check in full upon its presentment. And C. The subsequent dishonor of the check by the drawee bank for insufficiency of funds or credit or dishonor for the same reason had not the drawer without any valid cause ordered the bank to stop payment. As to the second way, the following are the elements. A. Any person makes or draws and issues a check. B. Such person has sufficient funds in or credit with the drawee bank. C. Failure to keep sufficient funds or to maintain a credit to cover the full amount of the check if presented within a period of 90 days from the date appearing thereon. And D. For which reason it was dishonored by the drawee bank. The 90-day period to deposit the check is not an element of violating BP 22. It is simply one of the conditions for the prima facie presumption of knowledge of lack of funds to arise, and it does not also discharge the accused from the duty to maintain sufficient funds in the account within a reasonable time. This is based on the landmark case of Wong versus Court of Appeals, docketed as GR number 117857, decided on February 2, 2001. If a person is found guilty of violating the provisions of BP 22, the penalty is imprisonment for at least 30 days but not more than 1 year, or a fine of at least double the amount of the check but not to exceed 200,000 pesos. The basis of these penalties are Section 1 of BP 22 and the Supreme Court's Administrative Circular Numbers 12-2000 and 13-01. In Administrative Circular Number 12-2000, the Supreme Court declared that the courts should follow the policy of redeeming valuable human material and preventing unnecessary deprivation of personal liberty and economic usefulness with due regard to the protection of the social order. Because of this, in lieu of imprisonment, a fine in an amount equal to double the amount of the check is considered appropriate penalty. In Administrative Circular Number 13-01, the Supreme Court clarified that the penalty is not removed but the court should reserve imposing imprisonment as a penalty for serious cases when the violation of BP 22 negatively affects the social order. We could not help but tackle the landmark case of Vaca versus Court of Appeals, docketed as GR number 181714, decided by the Supreme Court on November 16, 1998. In this case, the Supreme Court modified the penalty imposed on the accused by deleting imprisonment and only fined the accused in the amount double the amount of the check. After tackling about BP 22, it is now ripe to discuss the crimes involving checks under the revised Penal Code. Basically, there are two crimes under the revised Penal Code that cover checks. First is the crime of estafa or swindling under Article 315, Paragraph 2D, which has the following elements. A check is post-dated or issued in payment of an obligation contracted at the time the check is issued. B, lack or insufficiency of funds to cover the check. And C, damage to the payee thereof. The violation of this is penalized depending on the amount involved. Article 315 of the revised Penal Code provides the following penalties. A, prisión correccional in its maximum period to prisión mayor in its minimum period, if the amount is 12,000 pesos but does not exceed 22,000 pesos. If the amount exceeds this, the penalty shall be in its maximum period, adding 1 year for each additional 10,000 pesos. But the total penalty which may be imposed shall not exceed 20 years. The penalty of prisión correccional in its minimum and medium periods if the amount is over 6,000 pesos but does not exceed 12,000 pesos. And arresto mayor in its maximum period to prisión correccional in its minimum period if such amount is over 200 pesos but does not exceed 6,000 pesos. The second crime involving checks under the revised Penal Code is actually a list of crimes found in Title 4, Chapter 1, Section 3, covering Articles 166, 167, 168, and 169. We will not go into the details of the elements of Articles 166 and 167. This section covers obligation or security of the United States or of the Philippine Islands, which covers all bonds, certificates of indebtedness, national bank notes, coupons, United States or Philippine Islands notes, treasury notes, fractional notes, certificates of deposit, bills, checks, or drafts for money. Aside from this, you have to take note that the fines under Article 166 and 167 have been increased by Republic Act No. 10951, which was enacted on July 25, 2016. So, for your easier reference, we are showing the table of comparison based on the revised Penal Code, Republic Act No. 10951, specifically the penalties under Article 166. Now, we go with the penalties of Article 167. Rest assured that in a later lesson, we will be discussing the nature, degree, and period of penalties for clarity. For the moment, we still must know the penalties attached to the crimes committed. As to the effect of issuing worthless checks to the legal profession, several cases, such as the following, were decided by the Supreme Court. The Supreme Court penalized the lawyers who issued worthless checks by suspending from the practice of law, ranging from 6 months to 2 years, and even disbarment. In another lesson in the future, we will cover the causes and procedure in filing complaints against a lawyer. The laws and cases mentioned only tell the gravity of the act of issuing checks and forging the same. Quickly, you must know the causes of dishonoring a check. The following are the causes of dishonoring a check on account of the issuer or drawer. 1. Account is closed. 2. No account at all. 3. Drawn against uncollected deposit. 4. Drawn against insufficient funds. And 5. There's a stop payment order. Now, we go to the prescription of crimes. By prescription means the period within which a criminal case be filed against the person who violated the criminal laws mentioned. The criminal complaint for a violation of BP 22 must be filed within a period of 4 years from the time of the commission of the crime. For a violation of the revised Penal Code, the prescriptive period shall be determined by the amount allegedly swindled by the accused and the penalties involved respectively. Article 25 of the revised Penal Code provides that prisión mayor and reclusión perpetua are afflictive penalties, and that prisión correccional is a correctional penalty. And based on Article 90 of the revised Penal Code, reclusión temporal prescribes in 20 years. Other afflictive penalties such as prisión mayor prescribe in 15 years and correctional penalties prescribed in 10 years. You must remember that the civil liability based on a contractual obligation still continues despite the filing of the criminal cases, and the civil case based on contracts prescribed in 10 years from last demand. And if you plan to have a lawyer disciplined for issuing worthless check, the right to file a complaint does not prescribe at all. This means anytime one can file a complaint against that lawyer. As to the remedial law aspect of checks, the filing of the complaint goes through the same process as that of other criminal cases filed. A separate lesson on the process of filing a criminal complaint is allotted for easier understanding. For now, we need to address two basic questions. The first question is, where to file the case? You have to remember that the criminal case may be filed in any of the places where any of its elements occurred, like the place where the check was drawn, issued, delivered, or dishonored. The second question, which court takes jurisdiction of the case? For BP 22 cases, the information is filed before the proper municipal trial court. And for violation of Article 315 of the revised Penal Code, depending on the amount involved, the case could be filed before the municipal trial court or the regional trial court. In the next lesson, we will be tackling jurisdiction of courts based on BP 129 and other related laws. For cases against a lawyer, you can file your complaint before the IBP chapter in which the lawyer is a member, or even the IBP National Office or the Supreme Court directly. Aside from when and where to file the cases, you must know the defenses available to the accused. These are as follows. A. The dishonored check was paid within the 5 banking days from receipt of notice of dishonor. B. There was no written notice of dishonor given to the drawer or issuer. C. The stop payment was made due to a valid reason. D. The payee was informed that the check had no sufficient funds during the issuance. E. The respondent paid the complainant the value of the check before the criminal case was filed in court. And F. There is a substantial change or novation of the obligations of the parties involved. The most common defense for a violation of BP 22 is the lack of notice of dishonor. The notice of dishonor must be proven to have been actually received by the accused. So, if you are for the prosecution, you must make sure that the notice was received. Such notice may be sent by A. Personal service, or B. By registered mail. If done through the registered mail, the fact of sending the notice is evidenced by the registry receipt, the registry return card, and the affidavit executed by the person who mailed the notice of dishonor, establishing the circumstances surrounding the mailing of the notice. Relative to this, actual receipt of the notice must be proven by the prosecutor by the signature of the accused or his duly authorized representative appearing on the registry return card, and that such signature belongs to the accused or his duly authorized representative. Not only that, the prosecution must establish that the representative indeed has the capacity and authority to sign for and in behalf of the accused during the service of the notice. Thus, a security guard of a subdivision or a child of the accused could not be considered a duly authorized representative. While considering all these factors, we must remember the quantum of proof required in every case. In another lesson, we will talk about the different quantum of proof. Basically, what we must take note that one should be cautious in issuing checks and must make sure that the check is funded from the time it is issued. That is why, on the checkbook, there is a table that helps you trace the checks that the issuer issues or draws. It looks like this for BDO checking account holders. Again, these laws and cases that you now know only tell the gravity of the crime or offense of issuing worthless checks. Even if there's a change of policy as regards to punishment, the fact remains that the act itself has legal consequences. We hope that you learned so much from this 3-part lesson. We look forward to you taking the electronic quiz tomorrow. Thank you very much.